increasingly I'm finding that more and more Tennesseans realize that our state Supreme Court created a constitutional right to abortion in our state constitution, making us one of just 16 states in the entire nation that has a state constitutional right to abortion. Many of those same people, however, have heard that our state constitutional protections for abortion are even stronger, even greater than are required by the United States Supreme Court's interpretations of the U.S. Constitution. And they say, what does that mean? Well, let me give you an example. Several years ago, the United States Supreme Court said that it was constitutional under the U.S. Constitution to ban the grisly, gruesome procedure of partial birth abortion. However, because that ban might not cover all partial birth abortions that might take place within a state, several states began to pass their own state laws banning partial birth abortion. When that began to happen, some legislators in Tennessee went to our state's attorney general, our state's attorney, to say, would you give us an official opinion as to whether or not, if we pass the same language that the U.S. Supreme Court has said is okay, would it be okay in Tennessee? Would it be okay under our state Supreme Court rulings? And his answer was, it would be constitutionally suspect. In other words, he didn't know if he could defend a statute as constitutional under our state constitution that the Supreme Court of the United States said was constitutional. In other words, there are greater protections for abortions to the extent you couldn't even ban partial birth abortion because of what our state Supreme Court did. That's how extreme our state Supreme Court was in deciding whose voices should be heard on important issues regarding the health and well-being of women and our unborn children.